All right, welcome to the Explainer. Today, we're going to get right into something every medical professional needs to have on their radar: medical negligence and all the legal stuff that comes with it.
You know, it's the question that's probably in the back of every healthcare provider's mind. What's the line between a medical error and a full-blown lawsuit? Well, the answer is all about a legal concept called negligence. So, let's dive in.
Okay, so first things first, we have to really pin down what medical negligence actually means. Because, and this is super important, not every bad outcome is negligence. The bar is actually pretty high.
So, at its core, it's pretty straightforward. It's when a healthcare professional kind of veers off the established path, the accepted standards of care, and because of that, a patient gets hurt. This whole area of law is called a tort, which is just a fancy term for civil wrong.
And this is where things get really interesting from a legal perspective. See, since medical negligence is a tort, the person bringing the lawsuit, the patient, has to do all the heavy lifting. They carry the burden of proof. That's totally different from, say, a contractual issue, where sometimes the shoe is on the other foot and the doctor has to prove they did everything right.
So how does a patient actually prove it in court? Well, their legal team has to build a case with 4 essential parts. I love this analogy. Think of it like a 4-legged stool. If you kick out even one of those legs, the whole thing just topples over. The case fails. And here they are, the 4 legs of that stool. They're often called the 4 Ds to make them easy to remember: duty, deviation, direct causation, and damages. And I can't stress this enough. You have to prove all 4 for a case to move forward.
Let's start with the first one, duty. This is really the bedrock of the whole thing. A legal duty is created the second that doctor-patient relationship begins. The moment you agree to treat someone, boom, you have a duty of care. It's that simple. Okay, next up is breach, or what we called deviation on the last slide. This is really the heart of the matter. It's all about falling below something called the standard of care. And the big question the court asks is this: did this doctor act the way a reasonably skilled and careful doctor in the same field would have in the same situation? It's all about that standard. And last but not least, you have to connect the dots. The patient has to prove that the breach of duty directly caused a real injury. And that injury has to have led to actual damages, things like medical bills, lost wages, or pain and suffering. If a doctor made a mistake, but luckily no one got hurt, legally speaking, there's no case. It's the old no harm, no foul rule.
But what about those situations where proving exactly what went wrong is almost impossible for the patient, but the result just screams negligence? Well, the law has a really interesting and powerful tool for that. It's for when the thing speaks for itself. Yeah, it's a Latin phrase, and it can completely flip a case on its head. Res ipsa loquitur. It's basically a legal shortcut. It says, look, this is so obviously negligent that we don't need a bunch of experts to tell us something went wrong. What this doctrine does is it allows a judge or jury to infer negligence just from the facts of the incident itself. I mean, think about the classic examples, right? A surgeon accidentally leaves a sponge inside a patient, or operates on the wrong limb. You don't need a medical degree to know that shouldn't happen if everyone's doing their job correctly. Now, this isn't a free-for-all. The courts are really strict about when you can use res ipsa loquitur. There are 3 specific conditions that have to be met, like the doctor having exclusive control over what caused the injury. This makes sure it's only used in those really clear-cut, obvious cases.
So whether you're building a standard negligence case or using something like res ipsa, you need one thing: evidence. And the #1 legal tool for getting that evidence? The subpoena.
A subpoena is basically a formal, written order that says you have to do something for a legal case. Either show up to testify or, and this is huge in medical cases, produce documents like patient records. And you really need to know that there are 2 main flavors of subpoenas. First, you've got the subpoena ducis tecum. That's the one that asks for documents. Think D for documents. The other is a subpoena ad testificandum. That's the one that says we need you to show up in person and testify. Knowing which one you're holding is step 1. Okay, so let's get practical. One of these shows up at your office. What do you do? Well, before we talk about what to do, let's talk about what not to believe, because there's a huge myth out there.
Yeah, a lot of people get this document, they see the official-looking court name at the top, they read the words "you are commanded," and they panic. They think a judge personally signed this and they have to drop everything and comply that second.
But here's the reality. An attorney literally prints that out on the printer in their office. Now, don't get me wrong, it has the force of the court behind it,
But it is not a direct order from a judge. It's a legal request from one side of a lawsuit.
But, and I need to be crystal clear about this, that does not mean you can just toss it in the trash. You absolutely cannot ignore a subpoena. If you do, the attorney can go to the judge and ask them to enforce it, and that can lead to some really serious trouble, like being held in contempt of court, getting hit with massive fines. You get the picture.
So the key is to have a game plan. Know exactly what to do. If it's a subpoena for records, that's the ducis tecum, your first step is to check with the patient and make sure they've authorized the release. But if it's for your testimony, the ad testificandum, your very first call, no exceptions, is to your professional liability insurance company. And whatever you do, do not pick up the phone and call the lawyer who sent it without getting advice first.
You know, when you boil it all down, knowing this legal stuff isn't just about avoiding lawsuits. It's way bigger than that. It's about upholding the very integrity of the profession. It's about that fundamental trust between a patient and a provider, and making sure patient safety is always the top priority.
And that brings us to one final question to chew on. We're in an age where medicine is getting more and more complex. AI is starting to play a huge role in how we diagnose and treat patients. So, how is that going to change the legal standard of care? What does a reasonably prudent provider even look like in the age of AI? That's a huge new frontier for both medicine and the law.